Thanks very much. Hello and welcome to part 4 of our countdown to the UPC series. The current status. Before I begin with the subject of part 4, allow me to give you a brief update on the progress of the UPC and the unitary patent. So far, 6 countries have ratified the UPC, with the Luxembourg ratification rumoured to be close. This would leave just 6 countries to go, which must include the UK and Germany. Furthermore, the training of provisional legal judges without previous patent experience is underway, and the EPO is considering 2 proposals for renewal fees for the unitary patent. A final draft of the rules of procedure and news on the court fees is expected in the summer. The biggest development currently expected is the CJEU's ruling on the Spanish challenge to the legality of the unitary patent. This ruling will be handed down on the 5th of May. So, turning back to this webinar, I'm joined by Dr. Anja Lunzer, a partner in our Munich office, and by Dr. Paul England, here with me in London, a senior associate. We're going to move on to address the patent subject matter that the UPC is competent to hear, and how the court will make its decisions in disputes about these issues. This requires that we first start by looking at the structure of the court. The structure of the UPC. The UPC comprises a court of first instance, itself a network of divisions, and a court of appeal. The network of first instance divisions consists of a central division and several local and regional divisions. The significance of these different divisions is essentially jurisdictional, and complex rules apply to them, which we will explain in a subsequent webinar. The number of local divisions that a contracting member state is entitled to depends on the number of cases that have been heard in that member state's court over a period of 3 successive years prior to or subsequent to the coming into force of the UPC agreement. Each country is entitled to at least 1 local division, and an additional local division may be requested for each 100 patent cases heard every year over this period. This is subject to a total limit of 4 local divisions per member state. Germany is currently the only example of a country that will have 4 local divisions, but the UK may perhaps follow. Regional divisions serve 2 or more member states. The purpose of regional divisions is to avoid the cost, complexity and quality issues that might result if local divisions were set up in every member state. At the moment, the only declared regional division is that of the Nordic-Baltic region, which consists of Sweden, Latvia, Lithuania and Estonia, and this will be situated in Stockholm. However, it is possible that regional divisions would also be established for a number of Eastern and Southeastern European countries. Having its seat in Luxembourg, the Court of Appeal is able to hear appeals on matters of fact and law from the courts of first instance, as Paul will explain shortly. A registry which is responsible for keeping records of the cases before the UPC also has its seat in Luxembourg. In addition, sub-registries are situated with all the divisional courts of first instance, and are responsible for reporting the filing of new cases in those divisions to the registry. Subject matter competence. A largely unexpected outcome of the negotiations preceding the signing of the UPC agreement in February 2013 was an agreement at the political level to split the central division between France, Germany and the UK. The central division has its seat in Paris, with further sections in London and Munich. The central division is largely concerned with revocation proceedings and declarations of non-infringement. There are also circumstances in which an infringement action can be lodged in the central division or referred to it by consolidation of actions, which we will also explain in a later webinar. These sections are assigned different subject matter competences for the patent disputes they will hear. Centrally filed patent revocation actions, or those assigned to the central court under Article 33, being allocated according to their subject matter classification. The focus of the London court is chemicals and life sciences, whilst that of Munich is mechanical engineering. Paris is responsible for all other subject matter. The full subject matter competences are shown in the table taken from Annex 2 of the UPC agreement and shown in the slide. Subject matter in practice. In broad terms, these subject areas correspond to the three areas of technology for which most patent litigation in the national courts occurs: life sciences, electronics and telecommunications, and mechanical engineering. More particularly, the London section deals with diagnostics, medical devices and delivery apparatus, wound dressings, small molecule and biological medicinal preparations, and the formulation of such preparations. The Paris section deals with electronic circuits, radio and electric communications, including telephones and wireless networks, as well as calculating, computational and digital information storage. And the Munich section finally deals with machines, including engines and related equipment and systems, lighting, combustion apparatus, heating and ventilating equipment, heat pumps and refrigeration, as well as weapons equipment. Allocating patents by subject matter. This tripartite system requires a mechanism by which cases can be distributed without splitting up an action in which two or more patents have different subject matter classifications. The rules provide the following mechanism for achieving this. A, if there is only one patent in the action will be allocated by the registry to the section of the central division responsible for the subject matter classification of that patent. B, if there is more than one patent and the majority share a subject matter classification, the action will be transferred to the section responsible for that classification. Or C, in other cases, that is where there is more than one patent, but no majority sharing a single classification, the action will be allocated to the presiding judge of the section responsible for the subject matter of the patent first listed. If that judge considers the action would be better heard in another section of the central division, they may then pass it to the presiding judge of that section. If that judge then disagrees with that assessment, they must refer it to the president of the court of the first instance to make the allocation that they consider appropriate. The rules do not deal explicitly with the situation in which the subject matter of a single patent crosses classifications, such that it might be suitable to be heard in London, Paris, or Munich. An example might include a wearable medical device used for purposes of monitoring a medical condition and combining mechanical and electronic features. In such instances, the implication of the classification table is that the IPC classification provides the registry with the basis on which to make the correct allocation. There is no apparent basis in the rules or the UPC agreement upon which to challenge this allocation. Exclusive competence of the UPC. So what patent actions can the UPC hear? Article 32 of the UPC agreement lists those actions for which the UPC will have exclusive competence. That is, for which the UPC has been given jurisdiction to the exclusion of the national court. Remember that this is subject to the dual jurisdiction of the transitional period and opt-out available to classical European patents, which we discussed previously in part 1 of our webinar series. The Article 32 list is exhaustive as shown on the slide. The UPC therefore has exclusive competence for proceedings on the principal patent matters of infringement of patents and SPCs, including the recovery of damages and related defences, actions for declarations of non-infringement of patents and SPCs, actions for provisional and protective measures and injunctions, actions for revocation of patents and for the declaration of invalidity of SPCs. In addition, it has exclusive jurisdiction for matters of prior use and actions for compensation for compulsory licenses granted on unitary patents, further to Article 9 of the Unitary Patent Regulation. Furthermore, the UPC has the added power of deciding disputes concerning decisions of the EPO in carrying out the tasks assigned to it for the administration of the unitary patent system. However, does this exclusive list mean that the UPC is excluded from competence for other important matters? On this point, I will hand over to Anja Lunzer to discuss those actions which the UPC may also have non-exclusive competence.
Thank you, Simon. The list of actions under Article 32, Paragraph 1 is exhaustive. As regards actions that are not on the list, Article 32, Paragraph 2 states that the national courts of the contracting member states shall remain competent for actions relating to patents and supplementary protection certificates which do not come within the exclusive competence of the UPC. It is not fully clear whether the words remain competent imply that exclusivity is conferred on the national courts or whether both the UPC and the national courts are competent for these matters. From the structure of Article 32 and from the wording, it can be taken that if exclusivity of the national courts and the exclusion of the UPC were intended, the agreement would have explicitly said so. As this has not been done, the UPC is, next to the national courts, also competent to hear actions that are not included in the previously mentioned list. Objects of property. Article 7 of the regulation creating the unitary patent provides that a unitary patent as an object of property is to be treated as a national patent of the participating member state, determined according to a formula set out in Article 7, paragraphs 1 to 3. It is doubtful that Article 7 determines anything more than the applicable law. Indeed, if it also dictated the forum of a dispute about objects of property, this would require that any defense based on a unitary patent as an object of property would have to be decided in a national court, prior to or in parallel with the proceedings in the UPC. This would undermine the purpose of the UPC as a single forum in patent actions. Hence, it is clear that Article 7 only determines the applicable law, but not the forum. Rights to employees' invention and compensation. Another example is the right to the invention made by an employee and the compensation for employee inventors. These are, in principle, matters of national law linked to national territories. Nonetheless, there is no apparent bar on the UPC as a forum for such actions, providing that the appropriate national law is applied. Prior use and rights of personal possession are provided by Article 28 of the UPC agreement as defenses to an infringement of a unitary patent or classical European patent. These apply where they would have been available as a defense under national law in a contracting member state relating to a national patent. However, it is interesting to note that actions relating to the use of an invention prior to the grant of a patent are specifically listed within the exclusive competence of the UPC, but actions based on the right of personal possession are not. Hence, for the latter, non-exclusive competence of both the UPC and the national courts is given, but the appropriate national law has to be applied. With regard to patent agreements, disputes concerning the existence and terms of patent agreements, such as patent licenses, are also not included within the list of matters for which the UPC has exclusive competence. However, the existence of a license may nonetheless be raised in a counterclaim to an action for infringement under Article 32, Paragraph 1, letter A. Patent agreements are based on contract law. The contract law applicable, as well as the forum in which disputes concerning the agreement are to be heard, are usually determined by a governing law and jurisdiction clause. A claim for a breach of a patent agreement whether in regard to a unitary patent or a classical patent, would accordingly be brought in the country contractually agreed upon in that license. Thus, it appears to be open to the parties to a patent agreement to agree that the UPC will be the forum in which disputes about an agreement can be determined. Furthermore, what if the scope of protection of a claim or the validity of one or more licensed patents is put in issue in a national action under a license? In which forum should such issues be determined? Is it the court that has jurisdiction for the agreement under the contract terms, or is it the UPC? It is clear from Article 32, paragraph 1, that the UPC has exclusive jurisdictions for disputes relating to validity and infringement of patents. Hence, if an agreement stipulates that the governing jurisdiction for disputes is other than the UPC, these specific matters of infringement and validity must nonetheless be dealt with separately in the UPC. The only way to avoid such a split jurisdiction is if the parties agree that the UPC will have exclusive jurisdiction for disputes concerning the agreement. Unitary patents may be available for license of right by filing of a statement with the EPO to this effect. Article 8, paragraph 2 of the Unitary Patent Regulation states that a license obtained under this provision is to be treated as a contractual license. Hence, the same considerations apply as to patent agreements in general. Indeed, it might be preferable if such licenses were adjudicated in the UPC, given that actions relating to compensation for licenses of right of unitary patents fall within the exclusive competence of the UPC. Compulsory licenses are not among the actions for which the UPC has exclusive competence under Article 32, paragraph 1, and they are governed by the law of the country in which they are granted. However, there is no obvious reason why disputes regarding such licenses should not also be heard in the UPC on the same basis as other patent agreements. What is the role of the Court of Justice of the European Union in the new system? As Simon's earlier slide illustrated, the European patent system comprising the UPC also includes the Court of Justice of the European Union. After the opinion of the Court of Justice of the European Union of 8 March 2011, the UPC system was amended to make it clear that member states are jointly and severally liable for breaches of union law. This is now ruled in Article 22 of the UPC agreement. Furthermore, Article 23 of the UPC agreement provides that actions of the UPC are directly attributable to the contracting member states. The latter is consistent with the UPC as a court of the member states, rather than a discrete court sitting apart from the jurisdiction of the member states. The consequence is, as is now provided in Article 21 of the UPC agreement, that just as matters of union law are subject to referral to the Court of Justice of the European Union by national courts of the member states, they are also subject to referral by the UPC. It is also clear that referrals to the Court of Justice of the European Union can be made either by the divisions of the Court of First Instance or by the Court of Appeal, as is represented in the slide. Any proceedings giving rise to the referral must be stayed pending the ruling of the Court of Justice of the European Union on the matter referred. The rules governing the constitution of judicial panels in the UPC are designed to achieve 3 primary aims. First of all, the consistency in the quality of judicial decision-making. Secondly, the harmonization of the substantive law applied. And thirdly, harmonization in the application of the procedural rules. In order to achieve this, The judiciary of the UPC is organized around what is called in Article 18 of the UPC agreement a pool of judges. This pool is drawn from all the contracting member states and thus, in theory, brings a mixture of national skills and expertise to the court, as well as a range of approaches to substantive and procedural patent matters. The pool of judges is composed both of legally qualified and of technically qualified judges, and it is from this pool that judges are taken to populate the panels of the Court of First Instance and the Court of Appeal. Legally qualified judges are required to possess the qualifications required for appointment to judicial offices in a contracting member state. But this doesn't require that they are already judges in their respective home states now, nor does it require that they have a background in patent matters. Indeed, roughly half the current provisional list of candidates for legal judge are receiving training in patent law. Technically qualified judges, by contrast, are required to have a university degree and proven expertise in the field of technology, in addition to proven knowledge of civil law and procedural law relevant to patent litigation. Now, more specifically on technical judges. The pool of judges is intended to include at least one technical judge with the relevant qualifications and experience per field of technology. How the fields of technology are to be identified and how many there will be is unclear. It would clearly be unrealistic to provide a technical judge for each and every classification and subclassification of patentable subject matter in the IPC system shown on Simon's slide earlier. The role of the technical judges is to assist in the evaluation of expert evidence for the legally qualified judges where necessary. Consequently, whilst some knowledge and expertise relating to these subject matters may occasionally be necessary, at least in general terms, most expertise will need to focus on matters related to the more commonly disputed subject areas of the life sciences, electronics, and mechanical engineering areas. Technical judges are not, however, intended to substitute for experts. Fact-finding is to be done based on the parties' briefs and pleadings, and, only insofar as necessary, by hearing experts. To explain more about how and why the panels are organized the way they are, I hand over to my colleague Paul England in London.
Thank you very much, Anya. So let's examine how the judges are allocated to the various divisions. All proceedings in the divisions of the Court of First Instance of the UPC are to be presided over by panels of 3 judges, unless the parties have agreed that a single judge can sit. Of the 3, 1 judge of each panel will be designated as the presiding judge, but other functions may be delegated to 1 or more of the judges. So, for example, 1 judge of a panel will be designated to the judge rapporteur. This is the judge responsible for dealing with the management of proceedings up to the oral hearing. In regional and local divisions, a panel containing a mixture of judges who are local, these are shown in coloured in white on the slide, and foreign, these are shown coloured pink on the slide, to the country where the division is located. By local judges, I mean those from the contracting member state or states facing the division in question, and by foreign judges, I mean those from other contracting member states. The mix of judges on a panel depends on the familiarity of the member state concerned with patent cases. So a local division that has a record of dealing with an average of 50 or more cases per year over 3 successive years has a panel consisting of 2 legally qualified local judges and one legally qualified foreign judge allocated from the pool of judges. This is shown in the lower dark blue box on the slide. Those local divisions that have an average of less than 50 cases over 3 successive years have panels consisting of one legally qualified local judges and 2 legally qualified foreign judges, allocated again from the pool of judges. And that's shown in the upper dark blue box. By contrast, the panels of the regional divisions will always be occupied by 2 legally qualified judges from the contracting member states hosting that division and 1 foreign judge. And that's the light blue box to the left of the slide that you can see. But in addition to the legal judges on the panel, a technical judge with qualifications and expertise in the field of technology relevant to the dispute, these are shown coloured black on the slide, may be appointed to a regional or local division by request of one of the parties to the President of the Court of First Instance. Or the panel itself may make this request of its own initiative if it deems it appropriate, having first heard the parties. There is one other alternative, which is that the UPC agreement provides for the appointment of a technical judge in circumstances where a local or regional division has been seized with a patent revocation action. The central division, shown as the green box to the right, is constituted differently to the regional and local divisions. The central division has panels each consisting of 2 legally qualified judges from different contracting member states, but there are currently no rules governing how many of the legally qualified judges must come from the contracting member state hosting the section of the central division in question. There is also a technically qualified judge who sits in all cases without first having to be elected, as would be necessary in a local or regional division. And I'll come back to the importance of these rules in a moment. So, majority decisions and dissent. As I say, a technical judge may be appointed to a local or regional panel of the Court of First Instance, increasing the number of judges on the panel to 4. Obviously, that's an even number that could result in a split decision of 2 judges against 2. In these circumstances, the presiding judge's decision will prevail. But in all cases, including majority decisions, the deliberations of the judges of the UPC panels, when coming to a decision, are made in private and remain that way. However, a judge who dissents from the decision of the majority will be required to provide a reasoned written opinion signed by the judge in question, so that parties know what the dissenting reasoning was. There's also a full court, which I shall say a little bit more about shortly, which is different. This requires a 3/4 majority of the judges on its panel to agree to a decision, a rule that would currently require 9 out of the 11 judges who make up the full court to concur. As Anya said earlier, the UPC is intended to provide an even quality of decision-making and of the application of the substantive and procedural law across its various panels. This is obviously an important issue, given the pan-European effect that decisions of the judges of the UPC will have. It's this concern that the rules by which judges are assigned to the panels of the local, regional and central divisions, the Court of First Instance and the Court of Appeal, are designed to address. They attempt to do it by providing for the mix of judges on each panel that I've described, the judges coming from countries that are accustomed to varying levels of patent litigation and therefore with different judicial experience of the subject. The patent expertise of the national judges is of particular importance to the UPC, because it's expected that the national courts will provide the source, at least in the short term, for many of the legally qualified judges who will sit on the panels of the local, regional and central divisions of the UPC. As I've explained, those contracting member states that have an average number of less than 50 patent cases per year over a consecutive period of 3 years will have only one local judge per panel of 3 in a local division. The remaining seats on the panel will be occupied by judges from the international pool. This creates the opportunity to place more experienced judges in the majority with a less experienced judge. In particular, there are numerous judges from Germany, the UK, the Netherlands and France who have plenty of patent experience, and it's hoped that these judges will share their expertise when they are mixed on panels of the UPC with judges from countries where patent cases are more rare. As regards regional divisions, we've seen that these must have 2 judges on the panel who come from the contracting member states that the division represents. And there are countries that are expected to join regional divisions, of which Sweden is already an example, which also have a relatively experienced judiciary in patent matters. So Swedish judges can be expected to sit in the Nordic-Baltic regional division of the UPC, which will also represent the countries of Estonia, Latvia and Lithuania, which we've seen, which are less associated with patent matters. However, it does still remain to be seen exactly how other regional panels will be composed at this stage. So we mustn't forget about the UPC Court of Appeal. Unlike the Court of First Instance, the Court of Appeal sits in panels of 5 judges, 3 of whom are legally qualified judges who are drawn from different contracting member states, and 2 of whom are technically qualified judges, as shown on the slide at the top. However, in common with the Court of First Instance, technically qualified judges don't sit on cases concerning the administrative tasks of the EPO. Now, as regards the full court, in certain cases, the Court of Appeal has the discretion to refer the case to what is called the full court, which I mentioned a moment ago. There are those cases that are of, to quote Rule 238A1 of the Draft Rules of Procedure, exceptional importance and in particular affect the unity and consistency of the case law of the court. The presiding judge must propose such a referral, and it is the presiding judge who requests that the President of the Court of Appeal appoints them, and not less than 10 legal and technical judges of the Court of Appeal. The 10 represent the 2 panels of the Court of Appeal currently constituted. So in the event that the Court of Appeal should have more than 2 panels, the intention appears to be that appointees to the full court will increase by 5 judges, again legal and technical, for each additional panel. So these will be big courts. But what is the scope of appeal? What does it do? The first thing to say is that appeals against decisions of the Court of First Instance must be brought by the unsuccessful party within 2 months of the date that the decision is notified. Whilst the appeal can be based on issues of fact as well as law, facts and evidence may only be introduced on appeal if their submission could not reasonably have been expected during proceedings at first instance. So the power of the Court of Appeal to revisit the facts of a case is actually largely limited to circumstances in which new evidence has arisen at the appeal stage, rather than being a general power to review decisions of fact. Except in appeals against decisions on revocation and decisions concerning administrative tasks of the EPO, appeals do not generally have a suspensive effect. However, this is subject to the Court of Appeal deciding otherwise at the, in inverted commas, motivated request of one of the parties. So, for example, it appears that the Court of Appeal would have the discretion to stay a final injunction pending appeal. So finally, what is the wider role of the Court of Appeal in guiding the direction of UPC law? Well, the Court of Appeal of the UPC has all the powers of the Court of First Instance, and can either reject an appeal or set the decision or order aside, totally or in part substituting its own decision or order. However, unlike, for example, in the Netherlands, the Court of Appeal is not a court of cassation, which makes decisions of law on referral and then sends them back to the lower court, although it remains to be clarified whether this is actually intended to be the function of the full court. Instead, referrals back to the Court of First Instance from the Court of Appeal may happen only in, again in inverted commas, exceptional cases. Unlike the example of the Court of Appeal of England and Wales, there is no indication that the Court of Appeal of the UPC has any binding authority on decisions of first instance. Nonetheless, it is hoped that the rulings of the Court of Appeal, and indeed the full court, will establish a consistent body of case law which can provide guidance to the lower courts and, importantly, confidence to those parties whose disputes the court hears. Although realistically, this process can be expected to take a long time. And on that note, I shall hand back to Simon Coe.
Paul, thank you very much, and also thank you, Anya, for your presentation before that. We do hope that you found this webinar informative and that you will join us for the next update, the fifth update, which we will advertise in due course. And it's goodbye from Taylor Wessing. Thank you very much.